You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome back, listeners, to another episode of People, Places, Planet. I'm your host, Natalie Triana, and in today's episode, we'll be analyzing two major regional instruments, the Aarhus Convention and the Escazú Agreement. At their core, these instruments recognize a powerful principle. People should have a meaningful voice in decisions that affect their environments, as well as the tools to hold governments accountable when their rights and environmental protections are at stake. Both instruments include the following pillars: access to environmental information, public participation, and access to justice. Importantly, Escazú also includes specific protections for environmental defenders. While Aarhus and Escazú share many similarities, they are not identical. They emerged from different political, social, and legal contexts, and at different moments in the evolution of environmental law. In this episode, we'll explore those differences, how these instruments have been implemented in practice, and what we can learn from the approaches they take. Before we jump right in, I'd like to give a special shout out to our previous host, Sebastian Duque Rios. Sebastian is now going on to complete his Master's of Environmental Management at Yale University. We are so grateful for all of the incredible work that Sebastian put into the podcast. In today's episode, I'm joined by Kristine Perry, a senior attorney at the Environmental Law Institute who leads our organization's work on protecting environmental and land defenders. Kristine and I will be speaking with two incredible guests who have played important roles in shaping and implementing these two instruments. Our first guest is Jonas Ebbesson, Director of the Stockholm Environmental Law and Policy Center at Stockholm University. Jonas is a former chair of the Compliance Committee of the Aarhus Convention and has been a key partner in ELI's work on environmental defenders. We're also joined by Patricia Madrigal Cordero, a Costa Rican lawyer specializing in human rights and environmental law, and chair of the Committee to Support Implementation and Compliance of the Escazú Agreement. So now, could you all introduce yourself and tell us a little bit more about your work on this topic?
Sure. Thank you, Natalie. I'm really pleased to be here with you, Jonas and Patricia. I work at the Environmental Institute, and as you said, I do lead our work on environmental and land defenders. If listeners have tuned into other podcasts on this topic, we've discussed the project we're currently undertaking that looks at what happens after an environmental and land defender is killed in Mexico, Brazil, and Colombia in the last 10 years, if there's been an investigation, if there's been a prosecution, and really what are the commonalities, where are the threads tying successful prosecutions, and where are the gaps and opportunities to strengthen accountability and justice for these crimes.
Thank you very much for this opportunity. As you said, I am from Costa Rica, and I've had the privilege of being part of the Escazú Agreement process since its very early days. I started to work in the process of Escazú Agreement since 2012. And in 2014, I was appointed as a Vice Minister of Environment at the Ministry of Environment in Costa Rica. So I was part of the negotiation from 2014 to the adoption of the text in 2018. And then I proposed myself for the committee, and I was appointed in 2023 and has been the chair since. So I'm thrilled to be here and to speak with all of you about the Aarhus and the Escazú Agreement processes.
Thank you, Natalie. It's great to be here and to discuss the Aarhus and Escazú regimes. I'm Jonas Ebbesson. I'm a professor of environmental law at Stockholm University. I was former dean, and in addition to teaching and researching, I've done a lot of practical activities, including working with the Aarhus Convention. In fact, I have been, in one way or the other, working with the convention since it was adopted in 1998, when the compliance mechanism that we will be discussing later on was established. And I have also had the pleasure of following the developments in Latin America and Caribbean. So in 2014, I was invited to Santiago in an early phase of the negotiation. And then I happened to be in New York when the convention was adopted. And later on, I was participating in the second conference of the parties to Escazú.
Well, thank you both again for joining us. To dive right in, I want to give our listeners some context. So could each of you start by giving us some background on the Aarhus Convention and the Escazú Agreement? Maybe walk us through how each agreement came about and what challenges they were intended to address.
So both the Aarhus Convention and I think later on, of course, also Escazú Agreement, they stem from one significant moment in 1992 at the Rio Conference, which took place at the very important time geopolitically, where we have had the decline of the Berlin Wall, which meant that a lot of issues that has not been possible to discuss internationally now became possible. We had the International Criminal Court, international trade, but also the topic of our regimes. It would have been impossible in the 1970s or 80s to have a treaty on public participation, access to information, and etc. in international law. Except for the human rights treaties, there was no such thing. This was seen as a national issue. So this moment was very important. But what was amazing at the Rio conference with the Rio Declaration is that it defines a number of concepts that we can see later on has moved into international law on public participation, environmental impact assessment, polluter pays, etc. As part of that, this Principle 10, it sets out that members of the public should be able to participate in decision-making, they should have access to information, and they should have access to effective remedies and justice. And it's surprising to see now how Principle 10 was used in Europe soon after the Rio conference. The Economic Commission for Europe and the Minister for the Environment in Europe met to discuss these issues. They agreed on a declaration and some guidelines. And quite early on, I think in 1995, they agreed to start negotiating a binding treaty on this, which is quite amazing. So that was a very special moment. But I think that moment geopolitically is quite different from what we saw when the Escazú Agreement was adopted.
Yes, for the Escazú Agreement, we started in Rio +20. It was 2012. And our region, led by Chile at the time, came to the conclusion that we were falling short on implementing the Principle 10 of the Rio Declaration. And we had to do something about it. We could get a declaration that involved 10 countries of Latin America. And the goal was to move toward adoption of a regional instrument on access rights, like you said, the access to environmental information, public participation, and access to justice in environmental matters. And this process was carried out with the active and significant participation of the public. And by public, we mean one or more natural or legal persons, as well as associations, organizations, or groups established by people in the region. And also we had the support from the Economic Commission for Latin America and the Caribbean, ECLAC, as the technical secretariat since.
You never know when these kind of documents are adopted, whether they would survive, whether they will live for a year or two or will be forgotten, or whether like the Stockholm Declaration or the UN Universal Declaration of Human Rights, whether they will live for decades after that. But apparently Principle 10 is still alive and kicking.
Yes, and it is amazing what the Principle 10 says, and very simple, is that environmental issues are best handled with the participation of all concerned citizens. And that is a very powerful statement, because to do that for the participation, you need the access to information. And if you don't get the access to information or participation, you need administrative or judicial procedures that you can use to really gain those rights. But this statement about to handle these issues in the environment, we need the participation of all the people that is involved in that still today, and maybe more, it is very important.
There is one thing, Patricia, in your quote that I think is also important to highlight. You refer to all citizens, but both in the Escazú regime and in the Aarhus, we are also aware that is not only citizens within the very country. If an activity in Costa Rica causes harm to Nicaragua or Panama or the other way around, the public concern may stretch over borders. I think it's also very important to remind of that. That's not only citizens in the very country where the decision is made.
Thank you both so much for that comprehensive introduction. I think that history really gives us a helpful foundation for understanding these instruments and why they were needed in the first place. So let's talk a little bit more about what these instruments actually do. What rights do they establish for the public, and what do they require governments to do?
Escazú builds on the classic three pillars of access rights: access to information, public participation, and access to justice in environmental matters. And it covers Latin America and the Caribbean. We are 33 countries in the region. But by the end of the negotiation period, we added a fourth pillar, which is Article 9. And that pillar is about creating a safe and enabling environment for environmental defenders, individuals, groups, or organizations that promote and defend human rights in environmental matters, so that they can act free from threats, restrictions, and insecurity. This is very important for the region because, unfortunately, we are a region that it is very dangerous for the people that is promoting human rights in environmental issues. Then we can consider the creation and strengthening of capacities and cooperation as a cross-cutting element for the implementation of the agreement. And the governance structure is very similar to Aarhus. We have the Conference of Parties and presiding officers that are named in each conference of parties with one chair and four vice chairs. And then the committee to support implementation and compliance that was named in 2023. And we also have 6 elected representatives from the public that has a very important role in the process. And now we are in the process to elect the third generation of these representatives that has to build this bridge between the public and the parties, and the secretariat, which has been the ICLAC.
So for the Aarhus Convention, much of that is quite similar. We used to speak always of the 3 pillars of the convention: access to information, public participation, and access to justice. But increasingly, based on my experience in the committee, and I should say also inspired by Escazú, I usually refer to the 5 rights now. In addition to these 3, I think non-discrimination and also the right to be protected. The Escazú Agreement has a bold provision about protection of environmental defenders. There is a provision in the Aarhus Convention which is very important. It is not drafted in the same way, but it also sets out that persons should be assured the protection from being penalized, persecuted, or harassed when exercising their rights. So I like to speak of the 5 rights.
And also in the first article of the agreement, we have the right for every person, present or future generations, to live in a healthy environment. And as a region, we should remember that the San Salvador Protocol recognized this as a human right last century, and we have a tradition in the recognition of a healthy environment as a human right.
I think that is a good reminder, a good point. If we go back to the 1990s, there was very little jurisprudence in the European Court of Human Rights on environmental matters. And despite the Protocol of San Jose, there were also at that time not so much of human rights jurisprudence in the Inter-American Court. But I think in parallel to this development with the treaties on public participation, Rio, etc., the Human Rights Court started to develop their jurisprudence. So from the European Court, where there is no such protocol, there is no reference to environmental climate. It is very interesting to see from the 1990s up until now, the solid jurisprudence that the court has established, even to recognize rights in relation to climate change. And I think it's very important to stress that although the Aarhus Convention and I think the Escazú Agreement, they are not drafted in the way human rights treaties are, that everyone has the right to this and that. But it's clear that both regimes establish rights, and no one questions that. They are, in that sense, right-based. And this mutual synergy, I think, between the human rights regime and the mutual impact of these 2 areas of international law is, I think, very important for this development.
The evolution of these rights is so interesting, and one thing that stands out is that these instruments create pathways for members of the public to actually engage and challenge decisions. So could each of you share a case or example where you've seen Aarhus or Escazú make a tangible difference?
Of the 200 cases that have been received, far more than 100 to 150 or so have been also dealt with. One important case that got a lot of attention was a complaint by a member of the public in Germany that she had not been able to participate in the decision-making process in the United Kingdom about a nuclear power plant. And we have a history in Europe with a nuclear power plant causing transboundary harm with the Chernobyl case. So she complained that she did not know about this process. According to the UK's law, even members of the public outside the country were able to submit comments, and they should be taken into account. And they had a rather advanced system also online where members of the public could give comments. Her problem, though, was that she had no idea of this process until it was too late. So the UK had announced in the journals in the UK, reaching out to Inverness in the north of Scotland about this, but she had not received any such information, and she complained about that. And the compliance committee looked at this and said, okay, how are we going to deal with this? And where do we draw the line? How far away can you be? But we concluded that where she was, that was actually within the distance that if there is a nuclear power situation, she could be affected. So members of the public in Germany should have been informed in one way or the other. In magazines or with the help of the German government or whatever, there could be different practical ways, but it was the decision maker in the UK that was responsible to make sure that even members of the public in Germany were informed. And the committee concluded that, and that was actually endorsed by the parties at the meeting of the parties. And the UK has taken some step, not through legislation, but through instructions. So when there is a new applicant, there is now a pending case about another nuclear power plant. And the UK actually instructed the developer to put ads in the newspapers in other countries about the procedure. So I think this is a good example. Also, again, showing that it's not just limited to citizens in these countries.
So I think that the experience that we are having now is see the impact of these instruments, and we can see it in some cases of environmental litigation in the region. For example, in Panama, the Supreme Court declared unconstitutional the 20-year copper mining concession granted to a Canadian company because they found that it was based on outdated environmental impact assessment, and they considered it was a violation of the Escazú Agreement in providing access to information. And Mexico has a few court decisions, one in 2022 about the expansion project of supporting Veracruz, and it was ruled in favor of the community because the environmental defenders were trying to protect the reefs in that area. So now we are seeing the impact of this agreement in the different levels, cases, that even in countries that have not ratified, it becomes to the legal framework because it's a matter of human rights and environment.
This, I think, Ian, is a good case to show also how they mutually influence each other. We have seen the European Court of Human Rights referring to the Aarhus Convention, not that it is a binding treaty for the European Court of Human Rights to decide on, but it's a treaty that many of the parties to the Human Rights Convention are to parties to. And if I remember rightly, also in the Inter-American Court in its advisory opinion to Colombia,
yes,
it actually pointed out that human rights could reach actually outside the territory of the country. And I think these, in combination, I think here you can see there is an important development, as you say.
Thank you so much. Those were wonderful examples, and I think they really highlight the real-world impacts that these instruments can have on people and communities. Kristine, I'll turn it over to you to take us a little bit deeper into the similarities and differences between the instruments.
Hearing these examples, it's clear that Aarhus and Escazú share many of the same foundations, but they also emerge from very different contexts. I'd love to explore how these different histories shaped the instruments themselves. What was happening in each region when these instruments were being negotiated, and how did that shape the way they were ultimately developed?
I can make some reflections on the way they were developed, where I can see some similarities. I recall when the Aarhus Convention was negotiated and when it was about to be adopted, I was already at that time very interested in the development of an effective compliance mechanism of some sort. Soon after the signing of the treaty, they set up an expert group to establish that. And I was asked to represent the network of environmental organizations in Europe and to prepare the first position papers on what we wanted to have included. We wanted an independent committee. Many compliance mechanisms under other treaties have representatives from parties. They are not acting independently, but this should be independent. It should be possible for members of the public to submit complaints or communications. And we also suggested in this position paper that the accredited NGOs should be allowed to nominate members of the committee, although at the end of the day, it was for the parties to decide. The point was that at the beginning, quite a few countries were a bit skeptical. They were hesitant to say, well, no, we can't do this. But then as the negotiation continued, somehow they got more comfortable with these elements. And finally, at the first meeting of the party, the decision was made, which included all these three elements. And I think that we saw some similarities with Escazú, that rather than rushing off, I think this idea of creating a trust. I know that in the Escazú region that some governments are very worried about what the treaty would do, but I think to show that there is nothing to be afraid of. It's not like a zero-sum game that just because some get some rights, then others will lose. It's not that way. It's actually that we can build something together. I think it's a similarity that I could see when also following the Escazú Agreement, how important it is that all parts of society build something together.
Yes, and because of that experience in Aarhus, we had in Article 18 the Committee to Support Implementation and Compliance. And I think that we have to be very clear that we as a committee, we have to support the countries to comply with the agreement. So we can help the governments to go step by step, getting the standards. And the countries also accepted that the public could present communications to the committee in case of non-compliance. As a committee, we started with the dialogues with the countries. So we start working with Chile with the first dialogue with the party, which was very interesting, and you can see the report in our webpage. And then we have had dialogue with Panama and St. Lucia as well. So I think these functions of the committee is to create confidence and to see the role of the committee as a subsidiary body, as we are, to support parties itself and also to work with the public. Now we are writing the first systemical report about persons and groups in vulnerability situation, and we want to write this report with the participation of the public and the countries as well. And we have to understand that Latin America and the Caribbean is a very diverse region. We know we have to address the specific needs of different populations and try to face the barriers to the exercise about access rights.
That's a wonderful discussion. That context is really helpful for understanding why the two instruments have evolved in somewhat different ways. Now, looking both at Aarhus and Escazú, where do you see the biggest differences between the two, both substantively and procedurally?
Well, I see it that we have like the same approach, but it is very important how it's been the experience in different regions. I think in Escazú, we have been working a lot in environmental defenders. We create this group of open participation. We have had the 3 environmental defenders forum. First was in Ecuador, then in Panama and St. Kitts and Nevis. And the last COP, it was approved the regional plan for environmental defenders. And that is very important because in a lot of countries, the environmental defenders are not recognized as people that work for human rights in environmental issues. So recognition is one of the first steps in this matter that has to be important. And then to define as a country, as a region, at different levels, what are the measures that can be taken to protect these people? And that is very hard because we don't have a lot of good experiences in that matter. But we know we have to find ways to protect the environmental defenders.
So I can see, of course, there are plenty of similarities, and the Escazú builds on a lot of the ideas that were brought in Aarhus, but there are also, I think, important differences. But one thing that was striking at the time the Aarhus Convention was adopted, there was not in so many countries full recognition of the role of non-governmental organizations to act on behalf of public environmental interests. There is no such reference clearly in the Rio Declaration, but it was a big issue when the Aarhus Convention was negotiated that NGOs should be seen as having a legitimate interest that could make them engaged in decision making, and that will give them right also to request legal review and have access to justice. In my own country, it was not until Sweden ratified the Aarhus Convention that was introduced. NGOs could have standing if the issue was about the land that they were owning or something like that, but they did not have this general right to represent public interest. That was a major step for the Aarhus Convention. When it was adopted, it was soon after the collapse of the Berlin Wall and what we thought was the end of the Cold War. But this East-West was actually a very important driver and motivation. It was seen from the West as a way to introduce environmental democracy to the East. So the NGOs in those regions, they were very eager to have a solid legal ground for their rights. And in some of these countries, there have been very impressive developments since for the right of NGOs. In some of them, NGOs are still struggling very hard to be recognized. One very important difference, I think, is that the Escazú regime is very explicit about recognizing the situation of indigenous peoples. That is something that you don't find much of in the Aarhus Convention. Actually, there's no explicit recognition at all. And Sweden, Norway, Finland are some of the countries that have indigenous populations, and their rights are not explicitly mentioned. Of course, the Aarhus Convention applies and can be used by indigenous communities as well. But I think that is really an achievement in the Escazú Treaty.
When talking Patricia and Jonas, what I'm hearing from this conversation is that there's a lot of opportunity for the two instruments to learn from one another. That raises the question of whether that exchange is already happening in practice. Are the two compliance committees or others working within these instruments sharing lessons and experiences? And where do you see opportunities for more collaboration?
I think we should have more spaces to exchange lessons learned. We start receiving communications just last year at the end of the COP in Santiago. I have had some spaces with the chair now of the committee, but sometimes I wish I could have more dialogues because we are opening our own road and sometimes it's quite hard.
I think there is a lot to gain in both directions from having these kind of discussions. And given that the Aarhus compliance mechanism had been functioning for many years before the Escazú committee was established, of course, there is a lot to learn from. As Patricia said, there have been some good discussions. And I was invited both to Chile during the negotiations, but I was also a couple of times, I was in meetings with the Secretariat, and possibly you were there also, Patricia, when drafting the rules of procedure for the Escazú committee, and to see what could be used, the lessons learned from Aarhus, and then adapting them to the circumstances of Latin America and the Caribbean. And I think one influence from the Escazú regime to the Aarhus is indeed the establishment of the Special Rapporteur on Environmental Defenders. I think, again, the development in Escazú was also a source of inspiration for the discussions in Aarhus.
Thank you both. I really like the idea of these instruments learning from one another, especially because they are dealing with many of the same fundamental questions. How do you give people meaningful rights, and how do you make sure governments actually implement them? And that brings us to what may be one of the most difficult parts, implementation. Both of you have experience with the compliance and implementation committees for each of the instruments. How do these committees work, and what have you seen as some of the biggest challenges and successes in putting these rights into practice?
So when the compliance mechanism was set up, we had a decision by the meeting of the parties on the basic structure, but a lot of the practicalities were to be developed by the committee itself. And it is important, I think, to stress that the compliance mechanism, they are not courts, they are not judicial bodies. But having said that, international law is at the core of the activity. The committees are reviewing compliance with international law, and they do reviews, they come to conclusions, even though they are not binding in a way as a court's judgment is. They do have a normative impact. So it is very important that the compliance mechanism, while they are there to help, to assist, and to promote compliance and implementation in an amicable way, in a non-confrontational way, the integrity and independence of the committee, I think, is super important. And that it can make its own independent reviews and make conclusions that this state, this party is not in compliance with the provisions on access to information or public participation. So there are, on the one side, some quasi-judicial elements. But on the other side, there are other very important functions. The idea of due process should be kept in the compliance committee as well. If you have an NGO or an individual and the government on the other side, to treat them fairly is very important for the legitimacy and the trust in the committees. But also, and this comes back to Patricia's point, we regularly had dialogues. If we saw that there were some issues that were difficult, to make sure that the government trust in us. The government should not think that the committee is always going with the NGOs, and the other way around. The NGOs should not think that we are always siding with the states. I mean, it depends on the case before the committee. So some of these points, I would say integrity, law, due process, dialogue, and trust were some of the elements that I think was very important to create the functioning compliance mechanism.
We are a very young committee. We were set up in 2023. We were appointed in a process organized by the Secretariat, and candidates all over the region proposed their names for that. We are 7 in total, 2 from Mesoamerica, 2 from the Caribbean, and 3 from South America. And our first task was to work in the working modalities, and were adopted in the COP in Santiago in 2024. And then we start, with the support of the Secretary, they start to build this digital platform to present the communications and to host all the work of the committee. And the idea is that all the communication will be presented there, and you can track what countries are supposedly in non-compliance. But we also have to work with the public to train them how to use this platform as well, and the focal points from the countries, and keeping that balance of implementation and compliance. In one hand, we have to have the confidence of the country that we are supporting them to comply, and then we have to work with the public to express the confidence that they have to have in their countries. Because I think that the first thing that we can mention about the implementation of the Escazú Agreement is the political will from the states to comply with the agreement. And that is very important. We have now 11 countries that have developed the national implementation plans and roadmaps. And they have objectives in short, medium, and long-term goals. And then they present their advances to the Conference of Parties. And maybe for the public is not well enough, but from the countries, they are committed to comply. So we have to keep that balance as a committee and to show the public all the efforts that the countries are doing, and to share with the countries what are the opinions that have the public about the process that they are having. So it's quite a difficult balance that we have to keep, but it is very important for the agreement as a whole. Also, it's quite difficult to get the public understand that we are not allowed to analyze subjective situations. Our commitment is to promote the implementation and compliance of an agreement, not to look into personal situations. And because of the failure of other processes, maybe groups or people can think in a committee as a way to get some attention of the situation that they're going through. And that's also a very delicate balance, because our goal is to get the countries on the track of compliance, even if they have to pass improvements in their environmental law to fulfill plenty the agreement. That can happen, and that may take time. That's something important to recall, that sometimes we have to wait for the response of the government because they have to align their rules, their laws. So as we are not tribunals or judges, we don't ask the people to comply with all the stages within their own country, but they have to prove that they have been asking the institutions at the administrative or judicial procedures to get answer. And after that, they can go to the committee. They cannot go to the committee in the first instance. They have to have their process at a national level. And if they are not responding, then they can go to the committee.
Well, when I listen to you, Patricia, I think I have very similar experience about navigating to be sharp and criticizing when that is necessary, but at the same time creating trust with the same governments, that they should know that even when the committee makes a bold conclusion on non-compliance, to take that constructively. And on many occasions that has worked well. I shouldn't say that it has done so always, but I really see the point you say that the compliance committee has both the capacity and mandate to give advice. And I think some nice experience that we have had in the Aarhus Convention is that some parties actually come to the committee and ask, how can we implement this? For instance, during the pandemic, we had countries saying, how are we going to deal with public participation when we cannot invite people? And some governments were, if not abusing, they saw an opportunity now maybe to cut down a bit of participatory rights. So the compliance committee made a statement on the application of the convention during the pandemic. And there is neither in the Aarhus Convention or actually in the Escazú Agreement, is there any provision that explicitly allows for reducing the standards in any situation. So the committee was very firm in saying that there is no room for reducing the participatory rights, but you can find new modalities, new ways. And at some occasions, although it's not perfect, you could have public participation online. So the committee was working with that. But when the parties come and say, how can we implement this and that, I think that is a very good sign of the trust. And the committee should be there to help them to do so. Another point that we haven't come to, which I think is both important, but also increasingly problematic, at least in the Aarhus Convention, is that when the committee finds non-compliance, and that has been later on endorsed by the conference or the meeting of the party, and if the meeting of the party agrees, then it's also decided on a follow-up procedure to move towards compliance for these parties. And we have several cases in the Aarhus Convention where parties have taken the step necessary to get in compliance or closer to compliance, but also many cases where it has taken time, and honestly also cases where we have seen hardly any development. And these cases of follow-up had come to take an increasing amount of time for the compliance committee that I don't think was really thought of at the time when it was set up. But that's also a part of the dialogue between the governments and the committee, of course.
I think one of the central themes from this conversation is really referencing the three pillars found in both of the instruments, particularly access. If you have access to information, opportunities to participate, and access to justice. However, sometimes speaking out puts someone at risk, and these rights become much harder to exercise in practice. And that really brings us to environmental defenders. Escazú is the first international environmental agreement to include specific protections for environmental defenders. Patricia, can you talk a little more about why these protections are so important to include? And Jonas, on the Aarhus side, how do these protections emerge even though they aren't articulated in quite the same explicit way?
Yeah, when we started the process in the Escazú Agreement, we included this Article 9, and first as a statement, and then it became as it is now with the two paragraphs. And the first one is to recognize the importance of the people that is working in human rights and in environmental issues. The second one is the obligation of the parties to take adequate and effective measures to recognize, protect, and promote all of the rights of human rights defenders in environmental matters. But the third paragraph is also very important because it tries to work against impunity and is the obligation of the party to take appropriate, effective, and timely measures to prevent, investigate, and punish attacks, threats, or intimidation that human rights offenders in environmental matters may suffer. So we have a very powerful article with the three paragraphs. I never forget when we adopted the final text of the Escazú Agreement in March 4th of 2018. It was the anniversary of Berta Cáceres' birthday. And that was a powerful reminder why we're doing all this process. The situations of attacks, threats, intimidation, and murder of environmental defenders were increasing in the region, and we had to take appropriate, effective, and timely measures.
So thank you. And again, interesting to listen to the experience of Patricia. And as I recall it, quite early on in the negotiations of the Escazú Agreement was the situation of environmental defenders highlighted. So it was part of the discussion. That was not really the case, at least not in the same way with the Aarhus Convention. There is no reference to the term environment defenders. But the convention, in addition to the rights of access to information, public participation, and access to justice, it also has general provisions. And in one of those provisions, there is a clause saying that the parties to the convention shall ensure that persons exercising their rights in conformity with the provisions of the convention shall not be penalized, persecuted, or harassed in any way for their involvement. Now, in the first years, that was not so much discussed. And I understood when I stepped in as the chair in 2011, when the committee has been working for 5-6 years, that there was some uncertainty from the NGO community whether they could bring communications also about the more general matters, or whether it was only with respect to access to information, participation in decision-making, or access to justice. And I explained to them, of course, the entire convention is relevant. If there is an issue of compliance with any provisions, that is something you can highlight. And then there was a communication against Belarus. And in this case, there were a couple of environmental activists. They have been involved in a manifestation, an authorized manifestation, so it was nothing illegal. But after that, they were subject to treatment by the civil police and other matters. And they brought this case to the committee, say that this was a violation of Article 3.8. And it was a lot of work for the committee to say, how are we going to look at that? The convention look at the rights under the convention. It doesn't say anything about civil society organizations in general. We had to show that the harassment or the persecution was, or penalization, related clearly to something that had to do with the convention. But we could do so, and we also explained that in some cases, the burden of proof is on the government. If there is this accusation, and if it's clear that this had happened, the government has to convince the committee that this was not undue, this was not in the scope of the convention or whatever. And in this case, with the committee come to the conclusion that it was not only with these very narrow rights to information participation, but also in the more broader sense, the right which sets out in the objective of a healthy environment, that members of the public should have this right. So even to be part of an authorized and legal manifestation was part of it. And we concluded that, and the meeting of the parties endorsed it, and there was no objection from Belarus. So we had some constructive dialogue with Belarus. But then, as you know, things change with the Lukashenko regime, and he went very hard on civil society organizations in general. So just before the last meeting of the parties, for me, in 2021, just a few months before that, we concluded that Belarus is still not in compliance, but it was relatively ordinary. Then I get information from the Secretariat that the NGO that has brought the case to the Compliance Committee very actively, it has been killed in a way. The government has brought the case to the court to have this organization liquidated, to destroy the organization. And this was very extraordinary. What do we do with this? So the committee, we decided to make an extra report to the meeting of the parties. And this was the most severe case we have ever had. And there are a couple of, in quotation marks, sanctions that the Compliance Committee can recommend to the meeting of the parties. It is to issue cautions, and that had happened a few times. But the most severe, is to postpone the privileges under the convention for a party. At the end of the day, the meeting of the parties, after a certain extended process with an extraordinary meeting later on, decided to introduce this sanction to Belarus. It had the unfortunate consequence that later on Belarus left the convention. We knew of that. I remember when I spoke to the NGOs from Belarus that this may be the effect. And they thought, well, we have to stick to this anyway. They cannot act this way. So it is a very important case. Very unfortunate that Belarus left, because you rather have countries in the treaty, even if they don't comply fully, to keep the dialogue. But I think for all the other parties and from the NGOs, this was also good to see that there are certain limits. We cannot let the governments go. So coming back to the Escazú, this is a big issue in Aarhus as well. And the establishment of the Special Rapporteur on Environmental Defenders, I think, shows that this is a serious issue in this continent also.
Yeah, I think it's so important to emphasize that protecting environmental defenders is really fundamental to making these rights meaningful. People need to be able to participate, speak out, and challenge decisions without facing harassment or retaliation. And Jonas, I think your story about Belarus is an interesting example of how those protections have evolved under Aarhus, as well as the importance and sometimes the difficulty of holding governments accountable when those rights are violated. So looking ahead, where do you see these agreements going from here? What opportunities do you see to strengthen them, and what lessons might Aarhus and Escazú offer to other regions around the world?
I believe that joint work is very important. We should use human and financial resources in the best way possible. So there's still much to be done in terms of disseminating, exercising, and enjoying human rights. Still, it is important to work with the governments in order to understand the importance of transparency and to strengthen the rule of law and democracy, as well as public participation. I know that there are some efforts in Africa and Asia just agree on a declaration last year about access rights that they can start a process in their own terms. So each region has its own characteristics. But at the end, the result is the same. We aim to have a government that has a rule of law and where the people can participate, can get the information, and has any kind of access to justice. And it is still very important for the people to have this. In our region, we have right now 19 governments that has ratified the agreement, but still have 11 countries that are part of the region. So we must continue with the ratification processes in other countries, including my own, which has not yet done so. This is a platform for cooperation and capacity building, and that's why I believe that it has to be used also as an example for other regions to promote their own process.
I agree with you on that. I think we can see some positive developments. Again, if we look at in the last 30 years or so after Rio, things have happened. The Escazú Agreement, of course, stand out. But also, as you mentioned, Patricia, the discussions among civil society organizations in Africa and in Southeast Asia. And I agree with Patricia that the declaration made in Southeast Asia last October, I think, it could be a very important step. I think there is increasing engagement from environmental organizations and civil society, and I hope that the governments understand again that this is not a zero sum. The governments do not lose power just by granting rights to civil society. We should not forget the region where you are now, Natalie and Kristine, that there are some international treaties also for your region that actually one tend to forget that the NAFTA agreement, which was later on changed in 2018, has some rather bold provisions on participatory rights and access to justice in environmental matters. So we see this in different parts of the world. And I think to follow that development, that's a positive step. What we do see, I think, which is problematic now, is another geopolitical situation, hardening. So there have been a bit of change of priorities. But there is also a tendency to cut down on development aid, on financing international institutions. And I can see that that is something that it is affecting my colleagues who are now working in the committee, that they have less resources to do this. And sometimes you start to wonder if some governments do this intentionally. But it would be very important because this is an amazing creation that we see. So this is a bit worrying. We have also seen in some countries in Europe and elsewhere that some governments have been harder on going against environmental defenders. So I think there is a lot to do, and I think it's very important for civil society to show that this is beneficial for everyone.
Well, thank you both so much. It's been wonderful to have this conversation and to hear not only about the history of Aarhus and Escazú, but also about how these instruments are continuing to evolve and influence one another. The work you've both done in the space is incredibly important, and I'm really grateful you joined us today.
Thank you both so much for joining us. And Natalie, thank you so much for serving as our wonderful host. It's been great to hear your perspectives and learn more about how Aarhus and Escazú have developed, how they work in practice, and where they might go from here. We really appreciate you taking the time to share your experiences with us and with our listeners.
Thank you.
Thank you.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.